Analyst and Roca. And we're also talking to our friend James Kilsby, Chief Analyst and VP of US from VIXIO GamblingCompliance. Did I say that right, James?
No.
VIXIO, right?
You got it.
And you know what? Welcome, everyone. In today's webcast, we're going to be talking about the uniqueness of gaming, which is Florida. And what I mean by that is, you know, in I think in May, we had an interview with Mary Ellen Class, and I believe James was on that show also. Yes, you were, about Florida. And since then, we've had some really big changes and some really interesting issues go down in Florida. And that's what we're going to talk about it. James, welcome. Stephen, welcome. James, so you know, I was a little convoluted there, but so what exactly will we talk about in Florida? There's a lot that happened since we last spoke, my friend.
Indeed. Yeah. So to try to catch up, you know, what could really be sort of years of developments in just 3 or 4 months or so. Let's start with where we left off in May. That was just prior to the special session of the state legislature, which, frankly, as Mary Ellen Class very accurately predicted, the new compact between the Seminole tribe and the state of Florida had a smooth passage through the legislature to be ratified. And during that webcast, we saw that as the first of 3 hurdles that would need to be climbed over in order for the compact and its, you know, all of its provisions, including statewide mobile sports wagering, for them to take effect. So ratification by legislature was number 1. The second hurdle was for the compact to be either affirmatively approved or deemed to be approved by the US Department of Interior, as all tribal gaming compacts have to. That hurdle was also cleared on July the 6th, when the August the 6th. There we go. Yeah,
Sorry.
It's hard to keep up, but August 6th, when the Interior Department's Bureau of Indian Affairs said that it would consider the compact to be approved, deem it approved, which is essentially neither affirmatively approving it but not rejecting it. And that means that the compact is now considered to be effective to the extent that it is compliant with IGRA and with other federal laws. And that brings us on to the third hurdle, which is the inevitability, really, of litigation against certain provisions of this compact. There's already been lawsuits challenging the compact filed in both state court in Florida and federal court here where I am in DC. That was well telegraphed in advance, and that's where we are. The next stage of this compact is to see how litigation plays out at both the state and the federal level. And there's a couple of different outcomes that could flow from those cases depending on where they go. So to sum that up, we identified 3 hurdles. 2 have been cleared. The third and most pivotal, really, I think it's fair to say, least predictable, certainly, is the one that still needs to be cleared. The one other thing I should highlight, I guess, in Florida, that we have also seen in these intervening couple of months is commercial sports betting companies, or specifically DraftKings and FanDuel, and also Las Vegas Sands, the land-based casino resort operator. Both of DraftKings and FanDuel together, and Las Vegas Sands separately, so 2 separate initiatives. Both of those groups have filed proposed ballot initiatives for the November 2022 ballot that would, in the case of DraftKings and FanDuel, seek to authorize online mobile sports wagering under very different terms to those that are within the compact. And on the other track, Las Vegas Sands is seeking to amend the Florida Constitution to be able to expand commercial casino gaming at certain parimutuel locations. So I guess all of that is to say, the the Seminole Compact was not the last word on gambling expansion in Florida, and those interests that have sort of coveted the Florida market for many years are looking to, I wouldn't say exploit, because that's not the right word, but they are looking to weave around provisions of the compact that do allow for the potential of other expansion of other forms of gaming, and get those initiatives on the ballot next year.
You know, it's interesting, because I don't think anybody expected Sands to jump in there on this, even though there's always been talk about during the compact they were looking at, you know, Fountain Blue, and they're looking at other casinos and stuff like that. I think you know, when Sands jumped in, that was a little unexpected. So are we looking at two different initiatives, one for sports betting for FanDuel and DraftKings, and something else for Las Vegas Sands to expand into casinos? And that's what we're talking about, right?
Yes, that's right. Two separate initiatives, and I think that the timing of them, I'm not. There would be others in Florida that more specific expertise on this, but I think the timing and why they came out together was due to other legal changes in Florida related to PACs and how you could do campaign funding for referendums. So it wasn't a coincidence that those two initiatives emerged.
Yeah, you know what? I forgot about that, Stephen. What are they talking? Wasn't it like dark money or something like that? The initiative they passed it, so they just decided, oh, get it done, do the bums rush and just get it done. But that doesn't. Although Florida, you know, I'm not an expert on Florida gambling and stuff like that, Stephen, but that does make it a little more difficult. Now, one of the other things that we're talking about is that the Seminoles did come out and opposing these both initiatives. They said they called it a Hail Mary, basically. Am I correct? Where am I at?
I think that's right. They did call it a Hail Mary. Whether it is a Hail Mary or not, to be frank, I haven't looked at the polls, so it's hard to know the answer without having polling.
Well, they only said, they said it was a Hail Mary from interfering out-of-state corporations. So, you know, that was the big thing, out of state, and that's, you know, that's kind of a strategy I've seen before. So, Stephen, welcome. Good to see you again, my friend. We always appreciate you coming on. So, what do you think about this deal in Florida?
I think that the important thing here is, you know, kind of avoiding all the detail. The important thing is that there's a competition that's beginning, and we're seeing this now, and we're going to see it in spades in California, and it's going to be the commercial companies against the Indian tribes, and it's going to be maybe like we've never seen before. It might be somehow or other left only to sports betting, but my instincts are that this is going to deal with internet gaming much more broadly, and it's going to move fairly quickly. Right now, what we've got, of course, is in Florida, we've got the lawsuits. Those are interesting. The plaintiffs are, of course, are commercial entities, and you've got to wonder, you know, who's paying for the litigation, and, you know, if there's some sort of you know, PAC or organization that they're using in order to avoid the public position of commercial entities. You know, commercial entities somehow or other, you know, coming into the state and trying to dictate things. But what I see in that is that, you know, first, of course, the first case is those entities, and then the defendants were the governor and his one of his administration's regulatory business entities. And then, of course, that lawsuit was lost because it was an effort to enjoin it was for an injunction. And then that didn't happen. And instead, the compact was approved on August 6th. And once it was approved, then they moved their position, and the defendants became Deb Haaland and the people at DOI. I think that, the basic thing that they're of course upset about is the idea that that bets are placed, where received on Indian lands. That's the piece that they can't stand. And they think it's a violation of IGRA. They think it's a violation of the Wire Act, UIGA, and the Florida Constitution as well. IGRA states that compact negotiations may include the application of criminal and civil laws in jurisdiction. So the idea that there would be a negotiation between the governor's office and the tribe, Seminole, as to how they were under the civil laws were going to determine where bets were placed doesn't sound outrageous in the concept of a compact negotiation. So I think there may well be authorization there. Like, I don't want to get ahead of myself. This is litigation that is unprecedented. I don't think there's ever been a case quite like this before. But I think that that's one way that might be justified. And then you've also got, the Florida, when they approved this compact, they had the implementing law, which arguably supported and legalized this process of allowing bets to be placed on the reservation, even when they were taken, or actually made anywhere else across the state. So there's a couple of big pieces in here that are going to have to get decided. And I think per James's earlier comment, I think this is going to take a while before it sorts itself out. Several years, possibly.
So we're not going to see sports betting in time for football season in Florida, is what you're saying right now, right?
Well, no, I'm saying that the lawsuit will take some time. I would not be surprised if they open on October 15th as they've planned. They lost the first lawsuit to the extent that it was an injunctive lawsuit that tried to stop the tribe and Deb Holland from going forward. They lost the commercial entities lost that. That's why they have the second lawsuit, which is a Administrative Procedures Act lawsuit. So they don't have the declaration, the injunction stuff the way they used to in the legislation.
Well, we're talking about something even a little more deeper here, which is about the tribes being disadvantaged by IGRA for online gaming.
That's right.
And what was this is something that's finally coming to an head. We've been waiting for this standoff, which is the commercial gaming industry is not waiting for the tribes to catch up. As a matter of fact, they're using this more to their advantage to move forward, and the tribes are being left behind. You see what happened in Arizona. This was a big issue, and they said, no, well, you have about 12 tribes going for 10 gaming licenses or something like that in Arizona. But it is a bigger issue here, which is about IGRA and the limitations placed upon the tribes. So this is the thing that everybody was responding to, but that this was a very bold move by the Seminoles and by the Department of Interior by approving it. One of the things Brian Newland said, and you can help me here, Stephen, and he was basically saying that the tribes shouldn't be at a technological disadvantage just because things are moving forward with the technology and something to that effect. Am I correct?
Absolutely. I mean, it's clear to me when you read both this letter and read the Arizona letter as well, the approval in Arizona, that's an affirmative approval, not a deemed approved. And it is a very, very strong letter, a strong letter in support. There is, of course, some questions that are raised in the Seminole letter. It's not a affirmative approval; it's a deemed approved. And you're right about the ownership issues. That's what that problem is with regard to the pari-mutuels. But it did not in the mind of the Department of Interior rise to a level where they were going to deem the or they were going to deny the compact. Could they have? I don't know. I think that it seems to me that it's better, and I think this is what's going on, Victor and James. I think that the Department of Interior is recognizing the danger that tribes have, the danger being that they can be outcompeted in the internet world on whatever the game might be. And they are trying to give tribes the opportunity to come up with as many different ways of doing this as possible. And they're going to take a good hard look at that. Let me see if I had a quote I took on this that I thought was good. Class 3 gaming compact is unique and responds to the particular interests and relative bargaining power of the parties to the agreement. As part of the trust obligation of the tribes, the department must consider these unique factors as it undertakes its review. You know, when you think back on the way the department used to think about internet gaming and used to spend so much of their time claiming that they were never going to deal with internet gaming, this is a different kind of position, isn't it? And then he continues, you know, provided that a player is not physically located on another tribe's Indian lands, a tribe should have the opportunity to engage in this type of gaming pursuant to a tribal state gaming compact. That's kind of interesting. And then he continues, the department also recognizes the ability of tribes to engage in other models of online gaming involving state commercial licenses to accept bets off Indian lands. So there is a big problem, and you pointed it out, Victor, but the Department of Interior is giving tribes a lot of leeway to try to come up with solutions. And I think that that's an important piece in this. Go ahead.
I agree 100%. James, you know, you've been writing about this industry for a long time now. I think we've known each other for 10,
12
11 years, something like that, my friend. What do you think? You know, you've got your head wrapped around this. You've had your head wrapped around this for quite a while. So it seems like you have an administration that seems intent on giving the tribes any opportunity that they can possibly do, and that seems to be played out right here, obviously.
I would agree with Stephen's remark, really, that conferences and other sort of areas we've spoken about the issue of how tribes will participate in online gaming or online sports betting. It's kind of a binary question. Will tribes be required to obtain state licenses, like in Michigan, like in Arizona, and participate as commercial entities, or will they be able to participate in online gaming, online sports wagering under IGRA through a compact? I guess the two things really. The letter of the Interior Department. I think the outcome of the compact being deemed approved was expected. I'd have been surprised if it was affirmatively approved, and even more surprised if it was outright rejected. But so the outcome was expected, but the language that part of which Stephen just quoted, I think, was very encouraging, very forward-looking when it came to the Interior Department being very much open for tribes to offer statewide online gaming through a compact under IGRA. Yeah, I mean, clearly in the letter, the reference was there really to Michigan and Arizona and Connecticut. Tribes are free to make their own sovereign decisions to participate in online gaming on under those kind of state licensing frameworks, if it's in their best interest to do so. There's certain complexities there, but you could actually point to situations where it would actually probably be in a better economic interest of the tribes to do that in certain states, and it doesn't apply so much in Florida. So yeah, I think this was quite a bold step that was taken by Interior. If they were going to deem the compact approved and take no definitive action, they could have stayed pretty quiet on an issue that's going to be subject to litigation anyway. Chose not to do that, chose to frankly make a statement of policy, to my mind. Yeah, I think we probably need to let's see how this plays out in litigation, most importantly and primarily. But we may have to stop talking about this as a binary question as to how tribes are going to participate, under IGRA through a compact or through state licensing, and think of it as a option. And tribes tribes and states can determine what is the most appropriate framework for them to pursue.
I think everybody that's been watching this issue has come to that same conclusion that you've come to, James. It's just, I think we've all had to wrap our mind around this, and as things have settled down and we've kind of understood a little more, it just seems that's the way this has been played out, the way the letter has laid it out, and the way this is going to play out. Now, the lawsuits that have been filed, there's two of them. You said there's one that's in state and there's one in federal. What are we talking about? No,
I think they're both federal. Hold on for just a
federal?
second. Maybe I'm wrong about that. Hold on.
I think there's a couple
they're both federal.
There's a couple of lawsuits filed by the parimutuel interests in Florida.
Yes,
but there will be more, at least two more by the No Casinos group. Is in Florida, and I believe, the expectation is one will be in state court and one will be in federal court. And I think that probably, I know there's a number of things are going to go into the briefings, to show standing, to show harm, etc. But I think that probably the two key questions: one at state level, one at federal level. At state level, the claim is going to be that to allow sports wagering and craps and roulette, even potentially at the tribal casinos, that should require a referendum, because it's a new form of expanded gambling that hasn't been approved by Florida voters. There's an amendment, I think many people know, to the Florida Constitution of a couple of years ago that does require voter approval and a voter initiative to expand gaming, but also that referendum says that it doesn't apply to new forms of tribal gaming negotiated by a compact. That it's pretty easy to see how the Seminole tribe is going to defend that in state court, frankly.
You have to admit, though, I mean, it's just really quite amazing the way these pieces have laid out and the way it's played out for the Seminoles. You know what I mean? To have this specific issue play out like it is just really quite fascinating. They put all the pieces in place, and they were expecting this. But the deeper issue really is the commercial gaming industry not liking the exclusivity that the tribes have. Now, this was a compact that was negotiated with the governor, with the tribes. It's legal. It gives it really a strong standing in court, doesn't that, Stephen?
Yeah, it does. Now it's deemed approved. If it had been affirmatively approved, all the more. But I think that when you read this letter, I think you'll conclude that the issues that led to the deemed approval are a little bit to the side of the real issue that we're all talking about and concerned about, and that is, where the bet's going to be taken or where they're going to be placed. That issue doesn't seem to rise to that kind of a problem. So this is going to be, I think it's going to be a very interesting piece of litigation, and it's going to go on for a little while. I didn't realize that they were going to file in state court as well. That's pretty interesting. So you must think that this is going to take some time. And I think that, at least right now, they don't seem to be mounting a big effort to try to stop the sports betting from going forward. And right now, I understand that Seminole is getting ready for October. So I think we're going to see them doing their gaming, both under the compact, other forms of gaming, and this sports betting. We're going to see how much money they make, how much of an investment they put into it. And then, we'll start to be able to get a handle on the balancing between harm to one group and their real chance of prevailing in the litigation. And I don't see that myself, given the loss. If there had been a real interest by the court to slow this process down, they had a complaint that was filed in federal district court back in July and 30 days before the approval. So I think that this is going in a different way. I think it will be the kind of long-term. Let's just figure out what's going to have to happen with this. I think that the other thing that that interests me, Victor and James, is I find myself thinking back to the Schumer legislation in 2018. Do you remember that?
The federal bill
That's
that
right.
they tried to
Yeah.
push, right?
Mm-hmm. I kind of like that legislation now. At the time, I wasn't so sure, but what I like about it is I think it would, when you talk about Seminole and $500 million a year in exclusivity, it's all a little heady. When it comes down to smaller tribes in California, Arizona, across the country, this, in order for them to be able to benefit, they're either going to have to do something like many of the tribes did in Arizona, look at state law and see if they can find a way to do it that way. Or if there was some major piece of legislation in Congress, I don't know, maybe that's crazy for me to even think about that. But this piece itself, continues the idea that there has to be good faith negotiations. There has to be a tribal compact. It's not as if it's an end run around that stuff. All of the kind of the heart of the Indian Gaming Regulatory Act remains. They could make decisions. Back when Schumer did his legislation, it was only for sports betting. Interesting question. If you were to do legislation like this, would it only be for sports betting or would it be for other internet games? That's a different and bigger question. But if you kept it limited so that it was still something that was true to the Indian Gaming Regulatory Act, and it only addressed sports betting, you might get something passed. And I think it would really help the smaller tribes, the tribes that just aren't going to have, $500 million to attract attention. In Arizona, the tribes negotiate as one entity. Maybe that's a little bit strong, but they really negotiate as a team, and that gives everyone the ability to get something done. This is a tough issue, and if you're on your own, it would be very, very difficult for a tribe.
I get just to I guess jump up of that. You mentioned the core issue, core legal issue, arguably, of the compact of where where a bet takes place on the server, right, didn't raise to the level of an area of concern in a deemed approved letter. But what did was the notion that the tribe could ink marketing agreements, partnerships, skin partnerships with the parimutuel facilities. So the wording of the department was they would not endorse that model, for the concern that having a third-party brand running off the Seminoles platform via servers on Seminole land could mean that the tribe didn't have the sole proprietary interest in the operation, which is a requirement of IGRA.
Right.
But if we expand upon that and think about it in a bit more broadly across the Indian gaming landscape, what that does mean is that if a tribe is going to pursue, and again, there's litigation to come, there's different circumstances in different states, etc. And we're taking a couple of paragraphs of one letter and projecting quite a long way out in the future. So I'll just
and we're doing a great job of it.
Of course. This is the fun part. But we'll put that caveat out there.
Yeah.
But what I would take that to mean is that it would be very difficult under IGRA for a small tribe that was less well capitalized as a Seminole tribe.
Yep.
To they wouldn't be able to bring in an outside operator to run online sports wagering for them on a statewide basis on their behalf under IGRA, in the same way that, for example, the Bay Mills tribe in Michigan partnered with DraftKings. DraftKings runs as a skin under the Bay Mills license under the commercial framework in Michigan. You could not, I don't think you can replicate that model, which can work for a smaller tribe because you don't have a big capital outlay up front. You don't have to get knees deep in a complicated operation, and you frankly just take some of the upside as a revenue share as your primary benefit. And if you partner with a big operator, that can be decent amount of money for a limited amount of investment. So it's a model that can work for smaller gaming companies or smaller tribes, but I don't see how, based on the letter from Interior, you could do that under IGRA.
I agree. I think this is something that just pushes tribes to do state law. Because you can certainly do it under state law.
Exactly. And perhaps that's where the Assistant Secretary was going with the idea that it's up to tribes to decide the right model for them. Because I think, yeah.
Well, I think that's exactly what they were talking about, because remember, they were hearing the Arizona Compact. It was about, it was the end of April. And so it was only a few weeks behind the Seminole Compact in the approval process. So I'm pretty sure that's exactly what they were talking about. I agree with you completely on this. I just wonder, is there any chance that somebody could, like Schumer, could move forward and amend IGRA? That seems like an awfully tall order. That's what this would be. But you could take the position, honestly, straight face, we're not changing IGRA. We're just dealing with this one narrow issue. And if you did under this, I think that the small tribes could participate.
I think if I remember right, the Schumer-Hatch legislation was twofold in addressing tribal gaming and IGRA. It was deeming the transaction to be able to occur at the location of servers, and it was saying that a management contract under IGRA would not have to apply to a mobile sports betting operation, which I think again takes care of the issue of skins. There is the legislation in the House introduced by Representative Correa of California and Representative Katko of New York that the Oneida Indian Nation seems to be the driving force behind. That again touches upon this issue, although I don't think it does address the skins question and management contracts.
I don't think it addresses that, and I don't think it has language in it that requires that you go through the compacting process. It's narrower than that.
I think I absolutely believe you're right there. You could make the argument though that if the Seminole tribe is able to do statewide mobile sports wagering under its compact as it stands now, is that actually going to lessen the argument for the need to amend IGRA because it's already possible?
Absolutely.
There's
absolutely
a lot of politics involved that is not necessarily just the practical need for that. But yeah, I think the argument to amend IGRA for mobile sports wagering would have been a stronger one had this compact been rejected, and of course it could still get rejected in the courts. So that one of the conversations I'm hearing out there is from like companies like DraftKings and FanDuel. What they want to do is they're trying to be part of the solution for the tribes too. And I believe in Florida, at least in California, what I'm hearing, part of it is running another initiative because the tribes are not, the tribes like in California, the initiative does not include mobile for the one in 2022. So the rumor is that the sports betting companies are going to run a second initiative
and that's going to give the tribes an opportunity to get into mobile and stuff like that. Is that what we're talking about in Florida too? What does the initiative for the sports betting companies, what does it do for the tribes? It's the Seminoles.
So I think, in a way, it is quite similar in Florida. What the initiative being pursued by DraftKings and FanDuel would do would allow for commercial licenses, state licenses, to be issued to, well, big sportsbook operators that are already active in 10 states. So that's DraftKings, FanDuel, BetMGM, and a handful of others, or the Seminole tribe, a federally recognized Indian tribe in Florida. So the Seminole tribe is included in the initiative. Obviously, they are not part of it, and they're not supportive of the initiative today. But I think two points I would make. The compact does recognise this possibility of an alternative expansion of online sports wagering in Florida. So I don't think you can really make the argument that DraftKings and FanDuel are trying to subvert the compact when they are, they're picking up on a specific clause in the compact, and under that scenario, if this referendum got approved, well, the Seminole tribe would continue with its own mobile sports wagering and pay no revenue share at all, not instead of the 13 or 15% or whatever it is that's in the compact. So their revenue sharing obligations would go away, but it's expressly, this scenario is expressly recognized in the compact, which is clearly intelligently negotiated by the tribe, as the rest of the agreement is really. And then what we don't, there's a long way to go until November 2022. And so I guess this is an initiative that's projecting out into the future. And if the Seminole tribe is able, after court challenges, to launch mobile sports wagering, well, they're going to oppose that initiative next year, and they're going to fight it tooth and nail. I would have thought. What is an interesting scenario? What happens if a federal court severs that aspect of the compact that allows the off-reservation mobile wagers? So the Seminole tribe's sports betting is limited to on-reservation sports books, but it can't go forward with mobile. And then what becomes in play then is a conversation where, I think that DraftKings and FanDuel would reach out preemptively to the tribe and say, if that happens, you're in under our initiative. So why don't we get mobile done in Florida, where you win, you do get to do mobile, and so do we. So it's a preemptive. I would be tempted to see it as a preemptive strike, to see what for the eventuality, the possibility that actually the Seminole tribe can't do mobile sports wagering under the compact after all. So we'll see what happens.
That's how I saw the strategy too, as just preparing for an alternative in case that happens. And
the question
is smart. It's kind of smart.
I think
too,
so. Yeah, I think so.
Smart.
You've got to be. Can't wait to 2024. I think it's a sensible strategy in that regard. I guess the interesting thing is what happens if the Seminole tribe can go forward. A DraftKings and FanDuel are going to spend the money, the vast amount of money that would be required to get a 60% majority on an initiative that the Seminole tribe would spend a significant amounts of money trying to, we'll see. If the Seminole tribe can go forward, are we actually going to see a big battle, or does it become an unwinnable fight? But I do think there's a scenario where if a federal court does strike down statewide mobile wagering under the compact, then there will be conversations, I would have thought, outreach from the DraftKings and FanDuel to the tribe to try to get them on board with their initiative.
Yeah, it really doesn't serve FanDuel or DraftKings a purpose to be hostile towards the Seminoles, because they still have to negotiate across the country with other tribes and stuff like that. So I think it's incumbent upon them to find a path forward for everyone. And I think that's what they were looking at here is the strategy is like, well, if that gets knocked out in court, here's another option. And I think they're like I said, I think it's a smart move for them. But with the Seminoles coming out against their initiative, that just doubled the price of running that in the state of Florida, and that's going to become very expensive. And then also, I think the last thing they want is to have a fight in California also. So and just running a two-pronged fight like that is it's really interesting. And that's kind of why I wanted to have this conversation, because there is a lot going on here in Florida, and the ramifications to the other states is huge. You know what I mean? First of all, the deal the Seminoles negotiated was wild and masterful. You know what I mean? It was just a very bold step. I think we all agree.
Absolutely.
And so I think it kind of surprised everyone, but it doesn't surprise anybody who knows the Seminoles. You know what I mean? It should not surprise anyone at all. So, Stephen, so how do you think this is going to play across the country?
Well, I think the playing in California is going to be the first thing we're going to see. I've heard now too many times that another initiative, a competing initiative, is coming, and that competing initiative is coming from these types of entities. And so I think that's going to make some immediate impact. There's going to be some very difficult decisions that the people, the tribes that are running that initiative on retail sportsbook are going to have to make. Are they going to put something else out there so that they also offer a mobile? Do they have the ability to do that? I don't, it's going to be very, very complicated. And I think
go ahead.
I think that looking at that is going to be very, very important. And the people that are involved, them as well as I do, from the tribes, they're all top flight, very smart people. And I think we're going to see, yet another machination of the sort that James was talking about. I think we're going to see. It's hard for me to think that it will all be principle based. I would think that there would be some way for tribes to operate sports betting on a mobile platform, regardless of the way things play out in the initiative.
I think so too. You bring up a really important point too, is the fact that these initiatives that the tribes are running, defending, are retail only. You know what I mean? And that has a lot to do with the fact that going back to IGRA and stuff like that. We did have a question here. Somebody wanted to know, is there any precedent with New Jersey determining that a bet is accepted in Atlantic City where the servers are located as a matter of contract offer and acceptance? So obviously that's what everyone in this industry has been talking about when they first initially started about online gaming and sports betting in Atlantic City, that the bet was where the server is, and that seems to have been the precedent that everybody is running with. Is there something like that out there, Stephen or James, that you know of?
No, not that's precedent. I'm sorry. Go ahead, James.
Yeah, I seem to recall in the letter it was cited, the letter I mean, that deemed the Seminole Compact approved, states recognizing that the location of the bet could be at a server, specifically in New Jersey for online casino gaming. New York is doing that now for mobile sports wagering, as Rhode Island and a couple of others. That is referenced in passing. And I mean, I defer to you on this, Stephen, but that's sort of practically relevant, as this is not an off-the-wall suggestion to deem a transaction to be occurred at the location of a server. It's not, a totally radical thing for a compact to do. But yeah, I would have thought the difference is, though, there we're talking about state laws, state constitutions, whereas exactly. this is IGRA. So this is the first time that this has been, to my knowledge, this has been done under IGRA. So, and a legal challenge that did expect to come and never transpired, actually, against New Jersey's law for internet gaming, then the transactions occurring in servers in Atlantic City, that would go in the New Jersey state state court system, go up to New Jersey Supreme Court, whereas IGRA is federal. So I guess that would be my take of it. It's relevant, but not a direct legal precedent that is instructive for.
I think it has some persuasive value, but it certainly isn't a legal precedent. Not only is it, state law versus federal law, but if it was federal law, it's in a whole different district. So, I don't think you can cite it and say this controls. But I think, as you can see in the letter, I'd forgotten about that, but you're right, it is in there. I think that it is something that makes people think, well, what the heck? It was done in New Jersey, and didn't we all talk about it? And why is this a problem now?
I was just looking at a question. Yeah. Well, and the reason why we're having this conversation is because, again, the ramifications of this are I don't think a lot of people, if they're not paying attention, they should be paying attention, because the fallout from this thing is going to be huge. And more importantly, there's a couple issues here that people should be paying attention about, especially the idea about deemed approval. For the first time that I can remember, this seems to be a really big an issue with a lot of people. We've seen this happen before, but this is the first time I've seen so many people get upset at the fact that this process was done. I don't believe it's about 20 years old or something like that, Stephen. So why is this a big issue?
Media.
Oh, yeah.
It's a media issue. There are people saying, well, look, it's only deemed approved. But you know as well as anyone that, when was the last affirmatively approved compact in California? Long time ago.
It kind of. Do you think this is some of the fallout from the vaccination stuff too? People just don't know what to believe anymore. Is that what we're doing here? This is alternative facts type of stuff.
I think people are more susceptible now to media plays that are like that.
I think I have to agree with you, man.
I know.
You know what I mean? Sorry, James. I didn't mean to talk about you in front of your face like this. But, I don't consider you the media, James. I consider you. I consider you an analyst.
No offense taken. But no, deemed approved. There's absolutely nothing unusual about that in these circumstances, and it isn't It seems like quite to me to be the pragmatic way of dealing with this compact that is so large and broad in scope. If you were to reject a compact for areas that you have concerns about, we cited there was others, but one being the parimutuel branding agreements. This is a massive economic development agreement between the state of Florida and the Seminole tribe, and even I don't have reason to believe this is imminent, but the construction of 3 new resorts on land in Hollywood, there's a ton of jobs that will go into, and a ton of investment that would go into doing that, both tribal and non-tribal employment. So to not have the option of deeming a compact approved, it means you have to, what's the term, you sort of throw the baby out with the bathwater. This might be a British expression, but I think it means that you'd be throwing aside a huge positive agreement for both parties for that one area that you had some minor concern about. Whereas I think to deem it approved, it has, it shows quite a lot of this shows exactly. It's hard to get such a complex agreement together, such as this, and have every single part of it get 2 ticks on the part of the federal government. So to be able to allow the compact to come into effect and let courts decide any legally problematic provisions, it seems to me to be a non. I don't see what's controversial about that, frankly.
Well, it's definitely precedent setting. We have a question here from our friend Gary Green. A statement and the question goes, the Atlantic City question and the across the country issue is indeed important because the greater issue of tribal sovereignty is what is at the core with the new Seminole Compact here in Florida. It raises the potential for off-res betting, commercial bars, restaurants, convenience stores tied to servers on tribal land. Do you think the compact sets that precedent being discussed? And, you know, I think as a non-lawyer and someone who is privileged not to be burdened by a legal education, I would say yes. Sorry, Stephen, you took into that.
No, it's okay.
It does feel like it is precedent setting in many ways, you know. And go ahead.
No, I agree with you completely. I think that, you know, people know the way this compact has been done. Seminole is not quiet about it. And I think that, you know, it's going to change expectations in negotiations going forward. All of these compacts are negotiated. It's all a matter of persuading people. And I can tell you without a doubt that if this had been in place 3 years ago, when we were really, you know, hunkering down and negotiating with the governor in Arizona, certainly we would have had a bigger approach to this kind of a provision, because it makes a lot of sense. It makes a lot of sense. So yeah, I would expect if I were a state governor's office person again, which I once was, I would be, and starting up negotiations, I would anticipate them that is exactly what they are going to come to me with. And then I'm going to have to figure out whether I like it or not.
Yeah. And, you know, I think, you know, and, you know, a big issue here is the fact that, you know, with the tribes at a disadvantage with IGRA, there's not going to be a lot of sympathy from the commercial gaming industry for a lot of this stuff. I think you're going to see a lot more aggressive pushes into it where the tribes are either caught off guard or is not as strong. I think you're going to see some of them being rolled over. I think in California, some of the other states that it's still like Washington and Oklahoma, which still has a long way to go, but you're definitely going to see the tribes their exclusivity under assault. And I think that was kind of the core of what I was trying to get here today, is that, you know, sports betting provides a lot of opportunities, but there is an existential threat here that you need to pay attention to. There's a lot of opportunity, but, you know, you got to keep your eye on the ball. James, we are almost done, my friend. I really appreciate. So, you know, before, would you like to say anything to our esteemed audience about Florida?
No, I think honestly we've covered most of the ground there. So I just completely agree. I think this is as pivotal an issue for the future of Indian gaming and the gaming industry at large in the US as I can think of. It really is. And I think I was really going to finish by asking Stephen whether he can you see this even going all the way to the US Supreme Court? The issue of mobile, you know, can you accept statewide wages?
You know, I've had one case that tried to get to the Supreme Court. It was called the Rincon case, and the governor's office in California tried to get it up, filed a cert petition. It was denied. The process is very, very, very complicated and very difficult. I would be surprised if the Supreme Court thought that an issue, which is really a gambling issue, is something that they wanted to hear. At least, you know, now where there's no, you know, difference of opinions between the circuits on this. I wouldn't expect that. I would not be surprised if it went up to the circuit level, but after that, I'm not so sure. And you raised a very good point, James, and that is there a way that the parties can all get what they need regardless? And if so, how long will they wait for that?
That's a very good question. You know what, gentlemen, that's a great way to end today's show. First of all, I'd like to thank my guest, Mr. Stephen Hart. Stephen, it's always wonderful to have you. And you did a great job at the conference in Las Vegas. I appreciate that too. And speaking of next week, we're going to be talking about California gaming and the initiatives, and kind of look at this as a two-parter on exclusivity too. Mr. James Kilsby, my friend for a very long time, thank you again. We really appreciate your insights.
My pleasure.
Your brilliant reporting, and it's always great to talk to you, and we really appreciate you. And everyone,
always a pleasure to get another chance to look at your guitar collection, Victor.
Thank you. One day you have to come over and play.
Definitely.
I have a new one right here. That's a guild. I bought that one. I figure I earned that one. So again, we want to thank everyone. We'll see you again next week. We'll be talking about California sports betting next week too. So you definitely want to join us next week.
Victor,
thanks, Stephen. Thanks,
great
James.
to see you.
Thank you.
Great to see you, Victor. James, great to meet you.
All right,
hope we run into each other again soon.
Definitely.
All right, everyone. See you guys next week.
Thank you.
Thanks. Bye.
Bye.